Hello, everyone, and welcome to today's program, AI and Alternative Dispute Resolution and the Practice of Law. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speakers, Elizabeth Rothman and Ryan Abbott. Elizabeth is an attorney, author, and thought leader at the nexus of law and advanced technology. Her legal career is marked by a deep engagement in intellectual property, contracts, healthcare, and the evolving technological landscape. She, along with our second presenter, Ryan Abbott, are co-authors of the Elgar Concise Encyclopedia of Artificial Intelligence and the Law, published in 2025. And she publishes regularly on intellectual property, generative AI, and the legal and policy issues surrounding technical innovations. Elizabeth is an adjunct professor at the University of Southern California Gould School of Law and the University of Illinois College of Law. And she's on the faculty of Patent X, a certificate course on patent law and global public health offered jointly by Harvard Law School and the World Intellectual Property Organization. The full extent of her resume could keep us here for the entire hour, so I invite you to review her resume and her qualifications in the materials packet that you've received before this program. Dr. Ryan Abbott is a licensed physician, attorney, and mediator and arbitrator with JAMS. He has extensive experience in intellectual property, healthcare, with expertise in areas including biologics, pharmaceuticals, medical devices, life sciences, computer technology, and distributed ledger technology. Dr. Abbott has served as partner at a litigation firm, general counsel of a biotechnology company, and of counsel at a firm specializing in transactional matters and intellectual property litigation for life science companies. He has written widely on issues associated with law and technology, health law, and intellectual property in leading legal, medical, and scientific publications. He's also professor of law and health sciences at the University of Surrey, as well as adjunct associate professor of medicine at the University of California, Los Angeles. And now I'm going to turn it over to them so they can get started.
Okay, I'm just going to share my screen real quick. Thank you so much for that introduction, and very happy to be here today with Beverly Hills Bar Association. I'm going to start off by talking a little bit about AI in the legal profession today, an ever-evolving topic that kind of is just, constantly moving and changing and a very exciting area to be in. As was just mentioned, Ryan and I are co-editors of the Elgar Concise Encyclopedia of Artificial Intelligence and the Law, so I encourage you to check that out. It published at the end of last year. It is a concise reference work, so the first of its kind in recent years to bring together this intersection of AI and the law in this comprehensive way, spanning across 107 entries with over 100 experts authoring these entries from all over the world. And so it was a very, very exciting project to come to completion and to see in print, and just came out at the end of last year. Some of the insights learned from the encyclopedia, and this area of law is very, very rapidly evolving, and the implications of that for the legal world are constantly shifting. And understanding those implications requires deep collaboration between technologists and lawyers, especially where there are regulatory approaches varying significantly around the world and changing frequently. We really have to think thoughtfully and consider how to take these complex AI concepts and bring them into legal guidance that is functional for our profession, and that is an evolving and kind of ever difficult challenge that we're going to be facing going forward as a profession. So AI touches pretty much every area of law. I feel like I should have put a little asterisk in here because I'm sure there's something, but it really is at this point touching every area of the law that I can think of, and especially with governments and large entities around the world using AI so frequently, and the public adopting AI as well. Really, there are not many areas of our lives that are untouched by AI at this point. So even if you don't use AI, this still matters. And your clients are living in a world that is being shaped by AI. You are living in a world that is being shaped by AI, even if you're not using AI tools in your practice. AI is being used by courts, opposing counsel, government agencies, insurers, your clients' employers. Opposing counsel might use AI tools that affect discovery, evidence, jury selection, litigation strategies. Courts are across the country issuing using issuing AI specific rules and things that you're going to need to be aware of in the practice, kind of no matter what area you practice in and whether you use tools or not. The competence under Model Rule 1.1 now includes understanding the benefits and risks of relevant technology. So it's really part of our professional duty to understand these technologies, even if they're not being used directly in your practice. I have referenced a number of reports in these slides, and referencing reports on AI use is really difficult because everything is evolving so quickly. These reports are from 2025 and some actually that just published this year. But even so, the numbers are kind of continually increasing generally, but the concerns are a moving target as well. So I've just referenced these studies here so you know where I got some of the numbers from, and I believe these slides are available to you. So if you'd like to take a closer look, please feel free to do so. So AI matters for law firms, and the reason that it matters is that nearly 7 in 10 professionals, according to these studies, now use generative AI tools for work in some capacity. That's more than double what it was last year in just a single year. In large firm, that figure can reach 87%. There's a lot of incentivization around using AI in large firms, and that is just certainly showing up in the numbers. The top uses sorry, I'm checking out the chat as well. The top uses of generative AI in legal practice are drafting correspondence. About 58% of respondents said that they were drafting correspondence, legal research, brainstorming ideas, document summarization, and over 80% of organizations generally using some kind of generative AI at least weekly. So this generative AI use among firms has nearly doubled in the last year to 40% of firms. Many firms are now formalizing AI policies and governance structures to manage those risks and ensure compliance. And I will go through some of the things that you might want to consider when you're looking at your own firm's AI policy or putting together one from the beginning. There are a number of AI tools that you've probably heard of if you're on this webinar. Harvey and Legora, some of the largest two dominant legal-specific AI platforms being adopted by large law firms. Harvey was founded in 2022 and Legora in 2023, and they have a very large share of the market of large law firms. Thomson Reuters or Westlaw Co-Counsel is embedded into Westlaw, and so a lot of us are familiar with those platforms. The idea is that these models are grounded in the proprietary information of Thomson Reuters and therefore may have less hallucinations, although there have been some studies, and I'll talk a little bit more about it, where they're still found to be hallucinations in these models, so you still have to carefully review the output. Similarly with Lexis plus Protégé, their AI product, and claims to have less hallucinations. And in a 2025 Stanford study, it showed that there were still hallucinations, but again, these numbers can move and change, and there's not a lot of new data from these companies. So just being skeptical, with your own use of it and making sure that you're double checking everything is important. And then there are the more generic tools of ChatGPT, Copilot, Gemini, Claude. Many lawyers, especially in smaller firms, use these general purpose AI tools. They have the highest hallucination risk and the fewest legal safeguards involved. So very, very important if you're using any of those to be very careful about client information and double checking everything that comes out of the models. There's something like Claude's legal plugin, which is in a kind of research preview mode. It is a file-based plugin, so it's not a full legal platform. There are a lot of different platforms that lawyers are turning to and using um, for legal work or for drafting or for either correspondence or more significant drafting. So all important things to be aware of. Some of the promises of AI are that it will streamline legal research and memo drafting, automated contract review and due diligence review, faster case management and deadline tracking. And these are some of the more modest promises of AI. And then we have the perils on the other side. We have to look out for AI hallucinations, generating false citations, fabricated precedents, making up statutes, privacy risks that might threaten client confidentiality or attorney-client privilege. And and maybe more significant for the long term, over-reliance on these tools could possibly impact professional judgment and accountability going forward. So there are alarming rates of errors in AI models that are used for legal work. Again, these studies are there is not a lot of new data. There's not a constant update of the hallucination rate for these, especially the larger platforms. So this 2025 study did find that Lexis and Westlaw AI each hallucinated more than 17% of the time. And the general purpose LLMs were hallucinating about 58% of the time, which is very, very significant that there's errors or made up information in the output. Sanctions on attorneys are increasing as well, and there are over 1,000 cases now of documented hallucinations being submitted to courts. Hallucinations are not so easy to catch. A lot of large language models are not databases that are retrieving facts like we're used to with traditional research platforms. They are statistical prediction engines. They're trained to generate the most probable next word given what came before. And so the output kind of looks right by design. And the case names will follow real naming conventions. The fake citations will use real court abbreviations. It all sounds very plausible, but at the end of the day, it is not accurate. And so these fabricated holdings can track logical structure. Sometimes it's very difficult to catch, even for seasoned attorneys. Also, errors might cluster in places that you don't expect. So research shows that hallucinations are not always random. They're more likely when the correct answer is obscure or jurisdiction specific. The question involves older or less digitized case law, or the model is asked about a non-US system or information that wasn't trained on as well. Or if the prompt is phrased very confidently or in a direction that might skew the answer coming out, then you might get a hallucination that is moving in that direction of what the prompt was asking for if it is phrased very confidently. So these are all, sort of things to consider if you're using AI or your clients are using AI or opposing counsel in this environment that we're in. And then there are the data security and confidentiality risks with putting sensitive client information into a third-party platform. So the terms of service are a great place to go at first to figure out if an AI vendor is retaining any of your information, if they're analyzing it, if they're sharing client data that is input into the system, because obviously that can have very significant ramifications for attorneys if that data is disclosed. There's always, even if they are, have very tight data security procedures, there is always the possibility of some kind of breach. Vendor terms of service might actually even permit training on AI models on your client's confidential documents or your confidential documents. So firms really have to, vet the providers very, very well. And sometimes that means not taking what they're saying at face value, but digging a little bit deeper into their compliance procedures and encryption, and their guarantees around not retaining data. What I have found is that some vendors or representatives might overstate their security of AI tools, and sometimes that's out of a genuine misunderstanding for attorney obligations. No one's going to care as much as we do about the security of client data. And sometimes there's just a misunderstanding, or just they're not thinking about it as deeply as they need to be. And sometimes just out of commercial interest, they might overstate their security and data procedures. There's a formal opinion by the ABA in 2024 about updating compliance rules that lawyers must understand AI's capabilities and limitations. I won't go through all of these, but they are in the packet that you've received, and just understanding generally the technology that is involved here and maintaining your current professional responsibility standards with this new technology. The California Bar also issued guidance on generative AI in 2023. Basically applies the existing California rules of professional conduct covering confidentiality, confidence, supervision, and candor directly to the use of AI. And then just this last couple of months, there is a SB 574 was passed that aims to convert existing bar guidance into enforceable statutes. So look out for that coming soon. There are other laws in California and federally that would want to be aware of. SB 53, the first enacted AI safety statute requiring large AI developers to implement safety protocols. And then there is a tension between the federal government and states like California that are trying to regulate AI at the moment, and a lot of executive orders prioritizing the removal of barriers for AI development. And so trying to open up remove any kind of regulation, which includes these state regulations coming from, New York, Colorado, and California primarily. So you can take a look at some of these bills as well. Some interesting news about AI in the courtroom. There was a case in New York just a couple of weeks ago about AI-generated documents not being privileged because the client had initially drafted a document using a publicly available AI model. There are also a number of cases around sanctions for hallucinated case names showing up, and the supervising attorneys being held responsible as well. AI agents are another area that is has become the kind of new buzzword of the moment. And there's some concern here around giving too much access to AI agent platforms. An AI agent, unlike a chatbot that responds to prompts, an AI agent executes multiple tasks, usually autonomously. So they might send email, they might retrieve or update records, they might connect to external systems, file documents, make other conditional decisions. And often that is with minimal oversight in between actions that are being taken. So the lack of monitoring or potential kill switches to turn off the agents is a problem. If you deploy an agent into a system, can you cleanly shut it off and take it out of the system, or is that not possible? If agents are given broad access to confidential information, then that agent autonomously transmits that data somewhere else, there could be issues there with unauthorized disclosure. And then taking a good look at your contracts with these vendors and others would be important if you're instituting any kind of AI agents into workflow, because most law firm contracts were written for more passive and predictable software and not taking into account some of these agent issues. Okay. So as I mentioned, around 70%, maybe over that, of professionals are now using some kind of generative AI for work at some point, depending on which study you're looking at. That number has risen significantly over the last year, and I would expect that it will continue to rise with more tools being available and incentives to use them at a lot of larger firms. And around 46% of firms currently, according to this most recent study, have some kind of governance policy around the use of AI. This number has also gone up significantly, but the governance of the technology is not moving as fast as the adoption of it is by individual attorneys. So if you're looking at your AI use policy or looking to create one from the start, some good things to consider are looking for approved use cases. So define what the permitted AI applications are. Is it for research, drafting, summarization? Are you using it for more high-risk things? And if so, have you vetted the platforms well enough to use it for those purposes? If you might choose to explicit any kind of use of certainly any kind of unsupervised client-facing output, so things going directly to a client from an AI system would be at this point something you'd want to exclude. Data governance, so classifying sensitive data, applying minimization principles, and setting clear retention and deletion rules for data that's processed by AI systems. Requiring end-to-end encryption, having some role-based access controls, and monitoring AI platforms across the firm. And then having a significant human review protocol in place where you're mandating attorney review of all AI output before use, and establishing some clear error correction and escalation procedures when hallucinations are detected. As I mentioned, the hallucinations are often very, very difficult to catch. And so inevitably, if there's a lot of AI use in a law firm, some hallucination is going to get through, and having a procedure to detect and rectify these situations is important. So just some tips on developing an AI policy, assembling the right team. This is an interdisciplinary project. It should not just be delegated to an IT team. It really has to have the attorneys involved, thinking through all of the different angles of what could go wrong with the deployment of these systems. Auditing your current AI use can also be very, very helpful. So before drafting, find out what's actually happening in your law firm. What are attorneys using AI for right now? And then you can tailor your policy around that. And what are things that they might start to use it for, to make sure that you actually have policies that are usable for your attorneys. And then calibrating the risk profile. So a solo practice policy will look very, very different from a big law firm's policy. And drafting it in plain language. We all know that if nobody can understand the policy or remember it, then it won't be followed. So making sure that you're using plain language for a policy like this and not too much technical jargon so that everybody knows what the rules are to follow. And then finally, building in a review cycle. AI is moving, faster than technology regulation is. So building in a mandatory cycle for the policy itself is an important thing to do. So as I mentioned, the hardest part of AI governance may not be just writing the policy, but getting the lawyers to follow it. And so modeling good use from leadership, having role-specific onboarding, again, really thinking through what kinds of tasks people are using AI for right now and what they might move into later, and then figuring out how to train for those purposes. Integrating into existing workflows. And then this point of positive reinforcement, there's been a lot of mixed messages around the use of AI for the last couple of years, and if it is, allowable, if it's too risky. A lot of lawyers are choosing right now that they want to move in the direction of using more AI. So having a kind of culture around the use where it's not necessarily something that has to be hidden or something that is that they shouldn't be doing. But if you're going to incentivize it, then kind of creating some positive reinforcement as well, as opposed to just talking about cases where hallucinations have, there's been sanctions for hallucinations being submitted to a court, but finding the positive parts of it as well. Implementation failures, having a policy without training, outdated approved tool list. So if your approved tool list is very old and everybody wants to use the newer tool that is, the it tool of the moment, making sure that your tools are updated on there. Make sure you have an escalation path when there are errors found, and then keeping records can also be very, very important in figuring out where things have gone wrong if there is a problem. Okay, and this is just about responding to incidents that happen. Client communication, considering if you're going to, you should actually disclose to clients if you're using AI platforms, what you're using it for, maybe putting it in your engagement letter, defining a scope of AI use, oversight procedures, and even a right for clients to opt out of AI use. Okay. And finally, AI is here to stay. Strong governance of AI should not be a burden. It's a differentiator. Making sure that you have these policies in place is very important to build trust with clients. And for the near future, AI is more likely to augment lawyers than replace them, in my opinion, at least, regardless of what you have heard. And so I think, having policies and really governing the AI that you're working with is the most important thing at this point. So our role as professionals, staying informed, staying on top of recent guidance, advocating for governance and clear policies at your firms, and then leading with client-first decisions about using AI. If it doesn't protect or serve your clients to use AI for a certain purpose, then consider if it's something that you should be doing. Okay. And so AI is, if it serves your clients, use it. If it doesn't, don't, but be aware of all of these things and make sure that that you know that other people are using it as well if you choose to go the route of not using it. If you do use it, oversight is not negotiable. Meaningful human review is not negotiable. You have ethical obligations that will fall on you, and make sure that you understand the technologies enough to know what's happening in the market. And there's some sources at the end. And now I'm going to hand it over to Ryan. Thank you.
Well, thank you. It's great to be here with all of you, and I recognize many of you in the participant list and a not unsurprising number of AI bots that are here taking notes on behalf of the human overlords who are either not paying attention or just really want to re-listen to this without rewatching the video. The good news is, I think for everyone who's using an AI bot, the Beverly Hills Bar Association has promised a free hard copy of this encyclopedia to everyone. So look out for that. It is outrageously expensive and already out of date, having been published in December of last year. But not to worry, we're working on a sequel. I'd like to shift gears and focus a bit more on AI and ADR, as I am a neutral at JAM, so it's a topic that's near and dear to my heart. And I'd like to start with a couple of videos. There's all sorts of ways of measuring AI progress, and leave it to the internet to decide that one of the interesting metrics is what happens when you prompt a generative AI system with Will Smith eating spaghetti. This is what happened in around 2022, 2023, and as you can see, the results are somewhat less than realistic. Here is one from about a month ago.
That's the good stuff. And that's a wrap.
Progress. Progress technologically, which is all well and good. But for lawyers, all sorts of interesting impacts this is going to have. Economic and financial ones. The writer's strike, now of a couple of years ago, though who knows, it may be coming back, was explicitly about the use of AI in the creative industry. That's a whole other long topic. as Liz alluded to, people are saying AI is going to replace all lawyers. People have been saying that for a very long time, and I've still got a job, but we'll see what you think when we get to the end of this presentation. And then all sorts of substantive legal disputes that are likely to emerge around these things in obvious and some not so obvious ways. I'll run through some of that as a bit of groundwork for our AI and ADR discussion, one of which is synthetic content. So if you can make a video of Will Smith that isn't perfect, and you can tell it's AI if you're looking closely, but nothing like it was a couple of years ago. Not a new problem. Synthetic content's been around for a long time. After Abraham Lincoln's assassination, people wanted more presidential looking videos of him or pictures of him and didn't think they had enough. So they took an engraving of John Calhoun, his biggest political adversary, removed his head, put Abraham Lincoln's head on it, changed the title of some of the text there, and voila, you've got a best-selling portrait. But 150 years ago, it took a long time and a lot of technical skill to do something like that. And now I can do it in 30 seconds, and it will at least fool my uncles and aunts on Facebook. So this can be used commercially if I want Will Smith to promote my encyclopedia, which I have it on good authority that he does. If I want to use Will Smith for political disinformation, the possibilities are endless and problematic. And there's all sorts of interesting IP issues associated with these as well. Like, can you own that video of Will Smith, leaving aside the name, likeness, and image issues? People have been using AI to make creative works for a very long time, since the 50s and 60s. And the US Copyright Office has had a policy since 1973 that if you use generative AI, basically, you can't own its output. And this has been the subject of some interesting cases, one that just had a cert petition denied to the Supreme Court, and one going on in the District Court of Colorado right now. But just to give you a sense of how the technology is keeping up, I can go into Google Gemini right now and say, generate a creative image, and it will make a cat cooking a souffle. So a few years ago, there was a factual dispute about whether AI could make a creative work autonomously, or at least kind of stepping into the shoes of a human creative. Now you see, well, we passed that benchmark a long time ago. So, you can debate whether this is art or creative for all sorts of reasons. Copyright doesn't traditionally make that sort of distinction. The doodle I'm doing while I'm talking, where I'm making a doodle, and a great work of art get 70 years of protection plus my life. That's just the way copyright law was set up. But all sorts of interesting issues here, including as we're in Beverly Hills, or at least virtually, as music and movie studios and creatives increasingly use AI in complex ways of human AI interaction, lots of challenging ownership issues associated with that. And not something that has escaped the attention of at least the creatives who are writing about it, or the policymakers passing new laws about it, which Liz referred to. Lawyers have gotten into the act. You've heard some guidance on this. You don't want to be sanctioned for using generative AI. I did ask generative AI here about lawyer sanctions, but lawyers cannot seem to help themselves from having ChatGPT write a brief and then signing that brief without reviewing it. And I get the temptation and allure of it, but that has never been a permitted process. Whether you're having a summer associate, or your romantic partner who's not a lawyer, or your dog write your brief for you, you have to review every citation before it goes in. But there is no shortage of lawyers who continue to do this. Having sat through this webinar, you're not going to be one of them. People are developing all sorts of interesting new interactions with AI. So even people having romantic relationships with AI was not a super new thing, but the prevalence of it is certainly changing dramatically. And one of the most common uses of generative AI is for emotional support now. So people are interacting with AI in more and different ways than they have historically. And this has led to some negative outcomes from people suing ChatGPT, for example, for giving them bad legal advice or bad medical advice, or for inducing them to commit suicide, or for all sorts of negative possible outcomes. And of course, probably the most litigious current AI specific issue is this issue of copyright on the training side of things, though lots of claims being alleged all over the world, mainly in the United States. We're now up to, I can't remember the most recent number, but more than 60 lawsuits against generative AI companies, broadly speaking, by right holders, some of which have found fair use, some of which haven't found fair use, some of which have resulted in multi-billion-dollar settlements. So that's not going anywhere. It is crazy to me that as far away as one could have seen this coming, there aren't clearer rules and guidance on fair use and copyright, such that apparently you have at least 60 cases going on. But there we have it. And so the exciting news from all of this is more disputes, so more work for lawyers, which I assume most of you are, and more work for alternative dispute resolution professionals. And thus we get to kind of the use of AI in dispute resolution. And there are a couple of levels on which this is occurring. So one is AI in the substance of a dispute rather than AI in the process of dispute resolution. And I, together with another neutral at JAMS, Daniel Gary, co-created the JAMS AI dispute resolution clause and rules. And this is in recognition of the fact that there are several specialized practice areas in ADR, and there can be benefits to having rules tailor-made to those. JAMS has lots of different rules for lots of different things: employment rules, commercial rules, complex rules, distributed ledger technology rules. And now we have AI dispute clause and rules. And these largely track the commercial rules, but they have a few differences. First, they have a pre-done protective order that automatically applies because protective order issues are very frequent in AI-related disputes. And this avoids the cost and time and expense and challenges associated with negotiating a protective order. Second, it kind of follows a long-standing debate about whether neutrals should be generalists or subject matter experts and requires that neutrals in these cases be subject matter experts. So the benefit of that is that you are having a neutral involved in a dispute involving something technical where the neutral has a basic technical understanding of things. And so you are not trying to explain digital technologies to someone working in an analog environment. These rules can be put directly into dispute resolution clauses, or they apply automatically when AI is at the substance, the heart of the substance of a dispute that comes to JAMS. There's also a special process for reviewing highly confidential data. Often AI-related disputes involve highly sensitive trade secrets and confidential information, training data sets and the like, and so there are enhanced protections around that. And there's also a provision for neutrals to appoint independent third-party technical experts as opposed to traditional party experts if desired. All this in the mind of kind of having rules that are a bit more bespoke and solving some of the challenges that AI presents to dispute resolution, which can involve really highly technically challenging technologies, vast swaths of information, very contested discovery issues. And this is an effort to have ADR get the benefits associated with it: faster, more efficient, and fairer dispute resolution. Other recent notable developments in the world of AI come from another DR provider or ADR provider, the American Arbitration Association. They've recently launched an AI arbitrator. So this is not rules about the substance of a dispute. This is very much on the process of dispute resolution. And at the moment, the AI arbitrator only applies to documentary evidence only construction disputes, which were selected because AI is not currently well situated for resolving factual disputes. For example, evaluating witness credibility. It can do that. It is a controversial use case, but AAA is not using it for that. Construction disputes tend to be relatively simpler, legally. They tend to have relatively more prescribed and applicable rules. So it is a a good potential case study for this. And the way it works is both parties have to agree to use the AI arbitrator. You have an AI arbitrator that then appoints a human arbitrator. I just copied this rule because who would have thought one day we'd be looking at rules talking about how the AI arbitrator will select a single human arbitrator, but there you have it. The AI arbitrator takes all party submissions, generates basically a list of claims from them and a statement of case, confirms with the parties they're happy with that. It then gets submitted to the human neutral along with a draft award. And the human neutral, ultimately, the human arbitrator approves the draft award or can edit however they want the draft award. And so at the end of the day, it is a human award. So this is more sort of an AI augmented arbitrator. But why would someone do this? Well, the selling point is that AAA says it's going to be faster and cheaper. And this has certainly long been a selling point of using AI. It's kind of a selling point of anyone who's looking at automating something right now or augmenting. In theory, it will be cheaper and faster. And this is data that AAA promotes from kind of early investigation of it, not from having it used in actual practice. So we'll see what the data has. Some people also think that the AI outcomes may be fairer or better. To be sure, that's a difficult sort of thing to measure because all of these disputes are, fact dependent, and there isn't a kind of correct objective benchmark for whether the AI is getting it right, though there are ways to try and measure something like this, including, in research by having panels of neutrals evaluate decisions and deciding if they're right. Some parties don't trust AI. Some parties trust AI more than humans because they think they are unbiased or impartial. Though, the biases and partiality of the companies making AI have led to AI being called the fourth party in dispute resolution and the AI companies the fifth party in dispute resolution. But in any case, while controversial, this has moved forward. So we now have AI-specific dispute resolution rules and AI arbitrators. And if you're curious at testing this out, it is available at a cost, but you can also run your documents through the AI arbitrator resolution simulator, which will give you kind of predictions on how an AI arbitrator might resolve the case. This is sort of like getting an early neutral evaluation of your case before taking it to mediation or arbitration. And, dispute resolution, broadly speaking, AI is now and has been for a long time really autonomously resolving disputes. For any of you who use Uber or something like Uber, and these days that's probably all of you, very difficult to get a human being to resolve a dispute. Unless you say it's a safety issue and then explain that really it was that your promo code didn't work. If you try and initiate a dispute with Uber or these days half the companies out there, it will send you through an AI algorithm to just sort of resolve the thing, which can be both faster and cheaper and more effective or painfully frustrating, although so can be speaking to a customer service representative. The use of AI in dispute resolution is like the use of AI, well, like AI or the use of AI creatively, not a new thing. People have been using it since the 70s. Insurance companies have been using it, for example, to help generate, case outcomes and case value using kind of good old-fashioned AI, which was, traditional programming. If victim is a minor, then increase settlement value by 1/3. If victim was careless, then decrease settlement value by 1/3. This is sort of programmed in based on expert feedback. Most of the modern AI systems people are very excited about are foundation models built by a handful of large companies like Google and OpenAI and Anthropic and Mistral, on which many other providers kind of specialize or wrap those models to do interesting things. And they're largely based on machine learning, and they're largely based on exposing AI systems to massive amounts of data. So very different way of programming it, same basic outcome. And, AI's kind of first major success and debut in dispute resolution was with eBay in the early 2000s. So eBay, for those of you who remember using it, was a marketplace for buying and selling things. It still is. And early in the days of eBay, when there were disputes, parties would submit sort of open-ended complaints about what the dispute was, and a human neutral would try and get the parties to help resolve it. eBay set up an online dispute resolution process that was, effectively AI driven, and they made a few key changes on this. One is they prevented parties from sending in a 3-page letter about why the item didn't match the seller's description, and they just put in a radio button that said, I bought something, I haven't received it, the item doesn't match the seller's description. And at least in initial phases of this, the system tries to resolve it for parties without the use of a human neutral. This had several appealing features as a case study. One, these were high volume, low value disputes. So if you're fighting over a $50 item and my fee at Jams is somewhat in excess of $50 an hour, you couldn't really bring me in to mediate that dispute sensibly. Or really anyone to bring in that dispute sensibly, right? So the low value of it made it sensible. It was high volume, also relatively simple. So, eBay had some pretty simple rules on things. The risk of shipment is on the seller, right? So buyer says they haven't gotten the item. Well, that's that, unless the seller can prove they've gotten the item. So you don't necessarily need a 4-hour, caucus to figure that out. Something a system may help resolve. So eBay rolled this out and found that to everyone's delight and surprise, not only did it vastly improve settlement rates, but it improved participant satisfaction. It turns out that people were happier having an automated system help them with a voluntary resolution process over kind of the neutral-driven process. This quickly or eventually became the standard anywhere, internationally as well. It becomes extremely difficult these days to get human beings involved in some of these dispute resolutions, except at kind of very high value levels. This sort of process is also making its way now into the courts. So in civil court in New York now, you can register for online dispute resolution. Not everyone can qualify. You have to be proficient with the use of computers. You have to watch a couple videos. You can't have certain sorts of disabilities, for example. But once you're in there, the system has a, automatic, basically blind bidding process to try and get the parties to resolve a dispute before it even goes to the court. And this is something, courts internationally, particularly in some jurisdictions like China, where they've been more aggressive with this, have been leaning into, particularly where the process remains voluntary and party driven. There has not yet been much judicial adoption of binding, even reviewable decisions, although there have been in some jurisdictions, not in the US. There's also been for many years a variety of commercial products automating or augmenting kind of the neutral's role in dispute resolution. This is from one called Smart Settle. Other than Jams, I have no affiliation with any of these products I'm mentioning. But this allows parties to come in here and one party wants $1 million and one wants to pay $300,000, and they put their starting bids in and they put their bottom lines in, and the system helps them bridge the gap through an algorithm that isn't disclosed so that it can't be gamed, and there's benefits to a party for being willing to come down more earlier in terms of gap bridging. And in this particular system, for example, if the bridge gap can't be entirely bridged, you have the option of going to a human neutral or referring it to that. These systems aren't just for people fighting over dollar amounts. There are many of these systems. They're used internationally, and they even, are used in things like child, family dissolutions. So involving things like child custody that aren't, simple numerical figures being bridged. Now we have kind of AI mediators. This is a company called ClaimBright that is largely marketing itself to insurance companies. And, again, the pitch is this is an attempt to entirely replace me, at a much lower price point than Jams. And so, the mediator here is an AI bot and is, based on, of course, as almost all these companies do, based on one of the foundation models, specialized to, focus on mediation. And so these products are largely starting to roll out now, and there is not yet good data on their outcomes. There's also like training tools, for example, like Mediate, where if any of you want to try out your mediation skills, you can go on and practice with an AI bot and help the AI bot resolve some of its issues, and it will help score you and give you feedback on that. Then also Liz mentioned kind of lawyerly guidelines. There are also neutral guidelines out there, some proprietary to JAMS that are used internally, some from the Silicon Valley Arbitration and Mediation Center, dealing with, how should neutrals and parties be using AI? And as Liz said, you can't get away from this now. Everyone is using AI. Some of the times when I mediate, I'll go to a room, ask someone something, they'll ask ChatGPT, maybe their lawyer, maybe ChatGPT. I'll go to the other room, they'll ask ChatGPT, maybe their lawyer. So parties are using it. Counsel are using it to write mediation briefs and to kind of give predictions on case value and to create profiles of arbitrators and mediators. So these are being used extensively as well. And neutrals are using them both for guidance in mediation and for assistance in arbitration. And there are not yet kind of very clear guidelines on what's permissible and what's not. I think kind of the keys are one, confidentiality. So you have to be very aware of whether the AI system you're using maintains everything you provided in confidence. If you're using the free version of ChatGPT, for example, it does not treat what you put in confidentially. And so there was an interesting case a couple of weeks ago where a court found a client had waived privilege because they basically asked ChatGPT for legal advice. ChatGPT says, A, this isn't confidential, and B, we don't give you legal advice, so don't use it for that. Of course, people can't be helped. If as a neutral you were doing that too, a month from now, someone might ask it a query and it might say, well, in this dispute you had with, Nova Nordisk, they offered $1 million as a starting point, and that would be bad. Or it could be susceptible to discovery. A little less clear is, transparency and disclosure to parties. When is a disclosure required? It's always safer to disclose and get permission from the use of things. It could well be possible the parties could dispute, for example, an arbitration award if a neutral used AI without disclosing it. I think in that sense, it's not too unlike best practices for using clerks. And I think, again, the best practice is always to disclose things. And there are risks, for example, if the parties are giving you 500 documents they want you to review, with dumping those all in an AI and asking it to summarize those documents for you. At least at the higher levels of things, the parties are bringing you on to exercise your judgment, unless you're telling them you want to use a clerk or you're telling them you want to use AI and they approve of that. I'll end with this. AI is getting better and people aren't getting equivalently better. And so we have seen really some dramatic improvements per Will Smith in the past few years. It's coming faster and faster month by month. And this is a chart from a book by Ray Kurzweil from about 20 years ago, which shows basically this upward trajectory on AI progress. Sam Altman and Elon Musk say in the next 3 to 5 years at most, we'll have AI that can broadly do any intellectual task a person can do. Elon Musk said we'd all have self-driving cars a decade ago, so I take it with a grain of salt. He says a lot of things. I do have a self-driving Tesla, though, and I do like it more than I did 7 years ago when it used to phantom brake on the freeway all the time. But anyway, whether we get there or not, the next prediction is, well, then these computers will start improving themselves and become super intelligent, and there'll be really nothing for human beings left to do anymore. These are controversial claims, and I make no personal claim to when and if we're going to get artificial and general intelligence and artificial superintelligence, but the point is valid. These systems are only going to get better. So we will only get more adoption of these things. We will only get more sophisticated systems, and there is no getting away from it. So now's the time to figure it out for yourself. All right, I'll stop there so we have a bit of questions. And it looks like we have some questions and comments, unless these are disclaiming my offer from the Bar Association to buy you all a book. Liz, you want to start with these or
I think that they may be mostly for you, the around, and I think you might have covered some of them.
right? The first question is, I am a mediator. What duties of mediator to use AI for case analysis? For example, I have developed a program to do analysis of claims. Any suggestions or warnings using research and analysis using Claude work? Yeah, so I mean, I do think it's different in mediation versus arbitration. I mean, there's less in mediation. If you want to use AI to help you better understand the claims of the parties or to be a bit more evaluative, I don't think there's any firm rule against that. You know, I do think it is kind of a safe practice and possibly a best practice to disclose to clients that you use generative AI. Again, to make sure you're using something with an enterprise version that's keeping it confidential, and to the extent it's just helping you to understand things, I think that that is fine. Bearing in mind also AI isn't perfect. Aside from phantom braking in the freeway, it will hallucinate things, whether it's cases or it won't accurately reflect the statements of the parties. So, I always trust but verify and kind of make sure I've done enough diligence to be comfortable the AI isn't just making something up. The next question was, what platform are you using to generate the image of the cat cooking? And what platform can you use to generate videos based on a prompt? Well, this is perhaps a little more technical than I was here to answer, but I used Gemini for that. And so I picked Gemini for no particular reason other than I wanted to pay for an enterprise version of something, and I got Gemini early because I vaguely trust Google compared to alternatives and have sort of stuck with that. If you prompt in Gemini, it will direct you to their video platforms and help you make videos. But there are many free platforms for entering a prompt and getting a video, like make me a video of Will Smith eating spaghetti. I think if you just use the free ChatGTP version, it will do that or link you to it. It's not too hard to find online. And we have a third one. Are Mr. Abbott slides available? I don't think so. They're pretty much just pictures anyway, but not to worry. For those of you who want to read not quite an encyclopedia, Liz and I have written several things, and the Beverly Hills Bar Association is sending them out to all of you. You are welcome to have AI summarize them for you. And then we had here, I would like to confirm that at this time, AI is not considered confidential because it's from a third party. I think that is a fair point, but not entirely correct. I think it is a complicated answer to that question. In the facts of the case that I mentioned, for example, a court found that a communication was not confidential or privileged because it was to a third-party platform under a term of service where the communication was not confidential, privileged, or attorney-client privilege. I mean, if I was communicating now in a mediation over Zoom and the Zoom was being recorded on the Zoom platform, it would be a third party hosting data. But there is an agreement in place for Zoom to treat that information as confidential. So I think the lawyer answer, it depends. You have to look at your agreement with the third party in the context of the third party. If you're using it under an enterprise license the way that you would use, Excel or Word or Outlook, I don't think you will have significant confidentiality concerns, but it does depend. And when will the Beverly Hills Bar send out the book you referenced, Ryan Abbott? Yes, I think someone is going to get in a van right now. If you just send them your name and address, they're just gonna, kind of like paper boys used to do back in the day, just toss it toward your office.
Yeah, should we do a full disclosure that
Full disclosure, that was humorous. You're not really getting this book. Um, I thought an encyclopedia would be larger, though. It is pretty small, so it doesn't even work well as a door jam. But it doesn't cause back pain lifting it.
Those are true. And I would agree on the answer about confidentiality, that it really depends on the platform you're using, your agreement with that platform, their security procedures, and if they're retaining the data. And that's something that needs a lot of due diligence. So public-facing AI platforms, though, there's a lot more risk involved.
We have 60 seconds if anyone else has a burning question, or if anyone's Otter AI note taker would like to chime in with a question. Oh, here we got one more.
Okay.
Is it helpful to use multiple AI apps to compare answers for issues in mediation, getting different perspectives such as Claude, ChatGPT, and Perplexity? Well, that is certainly something people do. If you use different platforms and give it the same prompt, you may get a substantially different answer to it. Um, as a mediator myself, I'm not sure that I personally need that many different opinions from AI systems on some issue that I'm facing. But I mean, that is a problem-solving technique, and certainly for critical analyses or important questions, people do it. The cost of that goes up if you're using enterprise versions of things that have multiple subscriptions. Um, but I mean, you are welcome to play around with it and kind of see if you get better answers from one or the other. People, it's hit or miss what you get from any one system at any point in time.
I just wanted to jump in to address a prior question that was asked, and I think I answered it while I was speaking, but that the data could be outdated from studies about AI. And that is, yes, the data is outdated almost immediately from studies about AI because everything is moving so quickly. And that's why I put that caveat in the presentation as well, that take the numbers with a grain of salt, but definitely they're where there was marketing coming from companies about products being hallucination free, there were hallucinations in the products then. So just take, do your own due diligence on any tool that you're using.
On that note, I think that we have reached the top of the hour. So for the 58 out of 59 of you who were here for your CLE credits, I think that you have been punished enough. And go forth and have fun with AI. And if you want to reach either Liz or myself going forward, we're easy to find online.
Alrighty, this concludes today's presentation. Thank you so much, Ryan and Elizabeth, for an excellent presentation. And thank you so much to our audience. Have a great day, everybody.
Thank you.